We're joined now by Mr. Michael Bateman, who is joining us from his chambers in Newcastle and has over 50 years experience in the legal profession. And Mr. Bateman, which year was it that you were called for the bar?
1997.
1997. So what I'd like to speak to you today about is spousal maintenance. And when spousal maintenance might be applicable, it might not be something that people always seek legal advice about or make applications for. But if you could please share with us when spousal maintenance might arise, when it can be agreed to be paid or ordered to be paid, and for how long an order for spousal maintenance or an agreement for spousal maintenance might remain in place.
Right. As to when it might be applied for, the short answer is as soon as separation occurs. And the impetus for that is that usually, classically, there's a stay-at-home mum with young kids. Dad goes off. He's been the breadwinner, and suddenly the dad's wage stops coming into the home. Therefore, the mother has to rely on Centrelink and family tax benefit, which often is very insufficient to meet the needs of the family, particularly if there's a special needs child, or mum can't supplement the family income by working outside the home, either because young children require her constant attention or she hasn't got marketable skills. She might have devoted her married life to looking after children. So that's a classic situation. She can get an order then for spousal maintenance as distinct from child support for her own support. And that can be on an interim basis, that is pending a final hearing, or she can get it on a long-term basis, that is as part of the final hearing, having had an interim order to get her to the final hearing. So from the father's point of view in that case, it can be a thorn under the saddle because he is facing an indefinite future where a spousal maintenance order, if made finally, can be increased either with CPI or can be increased with increase of the recipient of the maintenance. For example, the mother might fall ill and need special care. The maintenance order can be increased to accommodate that, providing the payer, the dad in this case, has the capacity to pay it. So in terms of a mediation, and lots of parties come to mediation to try and resolve their difficulties, and quite sensibly, I think, because it's very expensive to go to a hearing, particularly if the thing goes into an appeal. You end up in the circular wash of what's called family law monopoly, and you want to avoid that because you can just go round and round spending lots of money. So the difficulty with spousal maintenance, once thought about, is how do you get a final order? How do you rule the line across it? There are provisions in the Act where you can have a lump sum, which gives you a certain amount of years. You can have an agreement that takes into account all payments as property and spousal maintenance. So there are ways to settle a maintenance claim. The interesting thing about spousal maintenance is that it has many uses. The first obvious use, apart from survival of the recipient of the maintenance, is that you can use it for payment of costs to get your case up and running. And we all know that legal costs are expensive. Legal aid is a diminishing return for lawyers. Very few lawyers lately willingly do legal aid, frankly, because they just don't get enough money to do it. So legal costs can be paid as part of a spousal maintenance plan. Also, if somebody wants to complete a course of education, say they're doing a university course to become a counsellor, for example, and the end result is within 3 years, they'll get enough money to survive. Spousal maintenance can be used to assist with payment for those fees for the course to get them through the course. So it's a limited spousal maintenance order for, say, 3 years. The other aspect of spousal maintenance is that it's very easy to enforce. So once somebody falls into arrears, there's a streamlined process where the court can order payment of arrears costs and seize property to assist in payment of arrears. So you've got all that armoury in front of you. The big problem with spousal maintenance, I find, when you get the brief fairly late, is that there are time limits. So in a de facto relationship, you must apply for spousal maintenance within 2 years of your separation. In a marriage situation, you must apply within 12 months of a decree of divorce. So that's often overlooked by the time I get the brief, and therefore you've got to seek leave of the court to be able to proceed. Leave of the court in both cases, as de facto cases or marriage cases, is governed by sections of the Act. And essentially, if you've been on a government-assisted pension at the time of separation, then normally you'll get leave to proceed for spousal maintenance. B, if you've attempted to settle the matter by agreement and the other side being corresponding, and there's a good excuse for failing to apply within the limited time, then normally you'll get leave to proceed. However, if you can't reach either of those ideals, then sadly you won't get leave to proceed on spousal maintenance. So that's a bit of a pitfall. Therefore, get your legal advice quickly on separation, and then you can set out a pathway to achieve what you want to achieve. And that includes, of course, a pathway to a mediated solution which avoids trauma, expense, and delay. And I find that mediations are becoming far more popular and utilised by a lot of parties. There are cases, sadly, where mediation is just impossible. And generally, final hearings for financial matters are only about, I think, 5% of the cases filed in court. So there's a 95% settle either by agreement or through mediation or other means before they get to court. So in a nutshell, spousal maintenance is well worth considering. And if you're a respondent, then you really have to consider ways to settle that aspect of the case. It's a very handy tool to travel the pathway, either through mediation or ultimately to a final hearing in court, and see it does give you a realistic means of living in the meantime.
That's been an incredibly helpful overview, Mr. Bateman. Thank you. And then look, I would add a D to that, and that was your opening message, which is that spousal maintenance is very distinct from child support, and that a party who's either receiving or paying child support ought not think that they are not entitled to spousal maintenance, that both of those forms of benefit can exist side by side.
Indeed. There's a bit of misconception about spousal maintenance. There's a story about the judge saying from the bench, "Mr. Jones, I'm going to give your wife $100 a week spousal maintenance." And Mr. Jones says, "That's very generous of Your Honour. I might chip in some myself from time to time."
All right, Mr. Bateman, it's nice to see that lawyers can still have a sense of humour despite the very difficult work that they do every day. Thank you so much for your contribution to our organisation.
A great pleasure, Ms. Bennett.
Goodbye.
Bye-bye.